Hello everyone, welcome to the channel Knowledge Star Continuous Knowledge Excellence. My name is Karuna Singh. Today on our show we have a very special guest, Mr. Vijay Dalmia, advocate. Welcome, sir.
No.
Okay, so let's start without much ado. Tell us something about yourself, like what are your practice areas and since when you are practicing? Yeah.
I am practicing since 1986 and it is now about 36 plus years in the legal practice. And I am practicing before the Supreme Court of India, Delhi High Court, and various other high courts all over India, high courts as well as other court, district level courts all over India. I am also practicing before various tribunals that includes tribunals relating to PMLA, Benami transactions, etc.
All right. So recently you have written a book on anti-money laundering laws. Share your experience.
Writing this book on anti-money laundering laws has taken a lot of time, and I started writing this book in the pandemic days. And it is a 500 plus page book. I have co-authored it. I have co-authored it with Mr. Siddharth Dalmia, advocate. He's also a practicing advocate of this Delhi High Court. And this book has been written by me from a practical perspective and from the perspective of what I can say, laymen, because a lot of trials and prosecutions are taking place in the domain of money laundering, and every day we read about cases which are being filed, invoked, people are being arrested in money laundering matters, relating to money laundering matters. So the idea was to educate people and to disseminate information about the anti-money laundering laws that are prevailing in India, and what are the nuisances relating to the same, what are the practical areas that require their consideration, a layman's consideration, and all those who are involved in these kind of cases. This book is, I think, going to be quite valuable for all professionals, including advocates, chartered accountants, company secretaries, and those who are into direct management and ownership of the companies, etc.
So what exactly money laundering is?
Money laundering is basically a technical term, and the act which deals with the money laundering is Prevention of Money Laundering Act, and it defines how money laundering takes place. And money laundering is not an independent offense, it is basically an offense based on another offense that is called a scheduled offense, which is committed by an accused person. So a schedule has been given under the Prevention of Money Laundering Act, describing the offenses. If any of those offenses are committed and the money generated through those offenses is basically laundered, only then the offense of money laundering is committed. So whenever we talk of the offenses relating to money laundering, there are always two offenses. One is the basic offense or predicate offense, and the second is the offense of money laundering. Money laundering offense is the result of commission of another offense and conversion of that money, layering of that money, or laundering of that particular money into the banking channels or legal channels.
Okay. There is a term PMLA. What exactly PMLA is?
PMLA basically describes it is an abbreviation of the Act Prevention of Money Laundering Act 2002.
Okay.
And this particular act describes the offense and punishment of money laundering, and it also describes the entire process and procedure relating to various aspects relating to money laundering, confiscation of the property, arrest, bail, uh, uh, collaboration with the foreign governments for the attachment of the properties, personal search, and so many other things. It
Okay.
also describes about the procedure relating to appeals, procedure relating to the adjudicating authority, etc.
Okay. So, what will you say about the current scenario relating to PMLA in India and prosecutions?
Like what you have to understand is that going by what we read in the newspapers, we have to understand one thing: the government is after any person and every person who is involved directly or indirectly into money laundering. And it is a hot topic these days, and the government is quite aggressive in relation to the money laundering cases. And there are lots of arrests which are taking place, lots of properties which are being attached, which are in uh, which are to the tune of thousands of crores of rupees, which are being attached for the commission of the offences related to money laundering. And a lot of prosecutions are also taking place. So at the moment, there is no respite, and the government is not going to be slow on money laundering, because the offense of money laundering is considered as a very serious offense impacting the economy of the country, and it is also falling into the category of not only serious but also in the category of heinous crimes which impact the socio-economic status of the society.
Okay. So, is it easy to get bail in crimes relating to economic offenses?
Very difficult, very difficult. Like I have already stated, that these are being treated as very serious offenses, and destroying the economic fabric of the country and destroying the economic structure of the country. Now this will fall into the category of economic offenses, and economic offenses are no more treated leniently or in a in a simple manner. These are being looked after by the prosecuting agencies, by the government, and by the judiciary in a very serious manner. And getting a bail in money laundering cases is very difficult. This is what I can say. It is not an easy task. Yes.
Okay. So, there are so many terms like trademark, copyright, design, and patents. So, can you please elaborate these terms? First, we will
Okay.
start with the trademark.
Okay. These are four elements of the intellectual property rights. Intellectual property rights is the umbrella under which the trademark, patent, design, copyright, all these kind of intellectual property rights come. Like when we talk of trademarks come. Trademarks are the logos or the names that are given to the products by which we identify the product. If we take the example of maybe Tissot watches, maybe Rado watches, maybe uh, Titan watches, or some other kind of watches. All these have been branded differently, and all these brands are known as trademarks. Airtel is a trademark. Uh, Hutch is a trademark. Similarly, when we go for breads, maybe English Oven is a trademark. Similarly, when we go for the service sectors, there are other trademarks available. Kirloskar is a trademark. Hyundai is a trademark. So these are the basic identifiers. Basically, trademark is nothing but an identifier of a product coming from a particular source. Now, Trademarks may be relating to the services, trademarks may be relating to a product. Like Airtel is providing services, it is not providing a product. A car manufacturer is giving you a product. So trademarks may be with respect to both kind of things. Now coming to the second aspect. The second is patent. What is patent? Patent is when you invent something which is new, original, and useful. So when we are talking of the patent, in case of patent, let us take the example of bulb. When the bulb was invented, so it was a new patent. Air conditioner, it's a new patent. Phone, it's a new patent. Mobile phone, it's a patent. There are hundreds of patents which are involved in a mobile phone. So each and every component of a mobile phone may be having a patent. So patent is a new invention. Patent is not discovery. We have to distinguish between the invention and discovery. Invention is creation. Discovery is merely discovering something which is already existing. Patent is with respect to something which is non-existing, which has come into existence for the first time. So when we talk of the patent, we talk of the new invention, not the new discovery. New discovery, let me give you an example. Finding out the properties of haldi, turmeric. So turmeric already has all the properties. If you are not aware, that doesn't mean that property was not there. So if you have derived that the turmeric can be used for medicinal purposes, then it's already existing and it's a discovery only. It will not fall into the category of patent.
Absolutely.
But when we talk of a bulb, maybe of television, maybe of a camera, maybe component of a phone, something like this, all these things will fall into the category of patent. Now coming to the aspect of copyright. When we talk of the copyright, you have to again understand copyright may be in the books which we write, copyright may be in the artwork, the drawing which we make, the pictures we make, the pictures artists draw, and copyright may be in movies, copyright may be in the sound recordings, it may be in the musical work, or it may be in the lyrics, it may be in software. So copyright means the right to copy. So you do not have, if I have drawn something, if I have developed something, if I have written a book, then that book is mine and it cannot be copied. Nobody has a right to copy the same until and unless I give a license. So copyright is different from trademark. In trademark, you get a monopoly over a particular logo, particular trademark, particular work. When we talk of the copyright, you get a right over that particular work. Now there is industrial design. Now you may have hundreds of types of glasses or table lamps or chandeliers, maybe ACs. All these 3D designs. Remember, I am using the word 3D designs. These 3D designs fall into the category of industrial designs. So all these categories of intellectual property rights are protectable under law, Indian law.
Okay. So is it necessary to register trademark, copyright, design, and patents?
Let me tell you, the registration of trademark is not compulsory but optional. Registration is always a good idea. You get a recognition from the side of the government as well, and a monopoly is created in your favor. Whereas, again, the registration of copyright is not necessary. Suppose you are taking a note on your notepad at the moment, or you may be drawing something. You may be, whether it's good or bad, your copyright has already come into existence. The moment you have put those notes are your copyright. So registration of copyright is not necessary. Registration is mere recognition. Same way, when we talk of trademark You may acquire the rights by way of registration. You may acquire the rights by using a particular word or a logo or a mark. But when we come to the patents and when we come to the designs, the rights are granted by the government. So registration is compulsory. Trademark, not compulsory, optional. Copyright, not compulsory, optional. But if you want to acquire a right of patent under the Patents Act, or if you want to acquire a right under the Designs Act, in that particular case, the registration is compulsory, and without registration, you won't have any right. You cannot go to the court of law claiming your monopoly rights.
So registration is very important.
Registration is very important for these two things as well as trademark, but for trademark it is not compulsory.
Okay. All right. So last but not the least, what message do you want to give to the viewers?
Now, coming to this particular last question, now there are many types of viewers who are going to be there. The law students, maybe the lawyers and the professionals and the general public. As far as general students are concerned, I would like to tell them that the legal profession is a gray hair profession. It takes time to grow in this particular profession. In this particular profession, money follows. You cannot follow the money. So you have to be very patient and you have to be very dedicated to this particular profession if you want to be a successful lawyer. As far as my professional colleagues and other professionals are concerned, I can just say that we are here to serve public, people who are in difficulty, and we should always try to help the public, and the rest of the things will follow in due course. And the last but not the least, for the public, it is necessary that they must understand the laws, because to handle the government and to deal with the government agencies, to present their case in the courts, they need to know certain basics. Without knowing the basic law, it will be very difficult for them to effectively contest for their rights and defend their rights. So knowing is the best thing. And as far as lawyers are concerned, and the law students are concerned, I'll say a lawyer must know something about everything and everything about something.
Absolutely, sir. Absolutely. Thank you so much, sir. Thanks a lot. Thanks for this wonderful interaction. And I would like to tell to my viewers, if you have any suggestion relating to this video or relating to the topics which has covered in the video, kindly let us know in the comments. And those who have not subscribed our channel till now, please do subscribe right now and hit the bell icon to never ever miss an update. So thank you very much, sir. Thanks a lot.
Thank you. Bye.
For more updates, subscribe to our channel, click the links shown on the screen to stay connected.